to do anything shady.
But I think it's important to just, to really familiarize yourself with putting up a trust. And having the right books and reading and really, really learning it and be knowledgeable at it. And then you can put one together for yourself.
If you want. There's also for the white site, there was a gentleman who actually did a YouTube channel too, where he actually broke it down as well. So he kind of goes page by page, he reads it, and then he breaks down like what each of those things mean. So that was very helpful too. To say, this is, he's like, this is what it really means. This is what it's saying. And it's good to have these dictionaries as well, because
because if you go to a lawyer or an attorney to do a trial, they're going to do one that they think you should do. The one that,
we shouldn't even be involved in lawyers and anything.
We shouldn't really be involved with lawyers, exactly, because they are meant to work for the crown, the government.
Exactly. And they'll be putting a whole lot of stuff in there that you don't even know, and you're trusting them, not realizing you're paying them all this money, and their allegiance is not to you.
It's not to you, exactly.
That's why I'm like, that's why we're doing all this studying and reading and stuff. So
right. Well, yeah, Christopher, that man, Christopher Hauser, on one of his videos, he said, don't hire a lawyer for nothing.
Exactly. I'm glad I did it when I was dealing with my property.
Don't bother with them.
No, I remember when I was dealing with my house in Canada, the bank's lawyers, every time I want to talk to the lawyer, I didn't even get access to talk to the lawyer. The woman that was, you have to talk to before you can talk to the lawyer, said I should get myself a lawyer. Well, luckily for me, my daughter had just, she has been called to the bar. So I got my daughter to deal with them. And she was kind of like, thinking she wasn't responding. When my daughter sent, her a letter with her, with her stamp, she responded immediately and I thought, interesting. They will respond, but because I said to myself, I'm not going to hire a lawyer and be paying. I didn't want to pay any lawyer's fees. I wanted to deal with my things, with my affairs myself.
Right.
You see, they're loyal to themselves because they know that, a lot of money is involved. So they kind of, pat each other's backs. Anyway, I was not fearful at all. I dealt with them, and my daughter got all the documents that I wanted from them.
Wow.
Yeah, for me.
Mother Flora, real quick, that book that you said was a volume 1 and volume 2. What was the name of that?
Yes, I'm going to have to, let me see, because I have to check it out online. Hold on. I saw it on Amazon. It was, whoever put it there, it was so expensive, more expensive than where, you can order it direct. Hold on, I'll find it for you. I'll do a...
Appreciate you. And then the other book was The Wise, Concise Handbook of Trust.
Yes.
Okay. You can go online and find that one, and they also again have a PDF fillable version for the.
I think I have the PDF if you need it, Mother, for The Wise, Concise.
Yeah, I have a PDF. I don't have it. In fact, I was thinking of buying the actual hard copy this for myself. Yeah.
Yeah, Trustee Handbook. It's right here. I can send it over to you right quick if you want. Oh, man. Look at all this good information. What's your email address? You sent me something before. It might pop up. MD Blakely or MD _
Yeah.
Blakely.
All right. Anybody else need a copy?
Yeah, I have a copy.
Okay, I got you, Mother.
And also, just to let you know, mothers, again, like if you're not really sure about how to, fill it, handwrite it or whatever, White Concise, do have a fillable version that if you go onto DuckDuckGo and look it up, they do have a fillable version that you can use to fill out your information. And once you fill out your information, you can give it to whoever it is that you need to give it to.
Okay. Well, I have a rough draft. I think I have the one that Noble Isaiah sent, but I just want to compare like 2 or 3. Just, I just like to compare information. Makes sense. Okay, so let me get back to what we were reading. Okay. Okay, so we left off on trust. Oh, did we? So the legal definition of res basically means it's a thing. Right here it was saying, for example, in a suit involving a captured ship, the seized vessel is the res, and proceedings of this nature are said to be in res or in rem or res. However, does not always refer to tangible personal property. In matrimonial actions, for example, the res is the marital status of the parties. Res, a Latin thing. In law, lingo is used in conjunction with other Latin words as things that. Okay. So I hope that satisfies your question. So let's see here. We left off up here. Privity of estate, expressing the trust with our signature and an AFV. In 1933, they took the goal from backing in Federal Reserve notes. A contract could no longer be completed. No consideration or value could be given. Common law vanished in public, so all contracts become colorable lies. So trust fills the void. Colorable contracts wrap a trust at the core. So everything is trust, and the gifting of the res into the trust, forming the corpus of the trust. Your signature is the representation of the trust, and all your past, present, and future labor or assets where your signature is the res or the value or the principle. Okay, so trust. If 2 parties have the 4 elements of a trust and employed one of the 4 methods of formation of the trust, then they have a trust. Recognized in law whether they know it or not, and the trustee can be held liable. So notice it says the trustee can be held liable. We are not trustees. Black's law, 2 kinds of trust, expressed and implied. Trust, the right, enforceable solely in equity in court, to the beneficial enjoyment of property to which another person holds legal title, a property interest held by one person, grantee or trustee, at the request of the grantor or settlor for the benefit of a third party, the beneficiary. Express trust, a trust created with the settlor's express intent, expressing the trust voluntarily, usually declared in writing, and ordinary trust as opposed to a resulting trust or a constructive trust. Implied trust, which is voluntary, also called constructive trust, your Social Security account, the form through which the conscience of equity, the court finds expression against one who has obtained property by wrongdoing. When property has been acquired in such circumstances that the holder of the legal title meaning you have possession over 90%, I guess, may not be in good conscience, retain the beneficial interest or title to the other 10th. So basically, it's basically saying that right now we're under an implied trust as the Social Security account, and they have possession of 90%. Wait a minute. May not, it says may not in good conscience retain the beneficial interest or title, the other 10th. Equity converts him into a trust. So I think what this is saying is that they hold 90% possession, and or what do you guys think this is saying? When property has been acquired in such circumstances that the holder, so they're the holder of legal title, and they have possession, right, of 90%, may not in good conscience retain the beneficial interest or title, which is the other 10th. Equity converts him into a trustee. They deem us to be holding title illegally, and they convert us into the trustee. It is sometimes said that when there are sufficient grounds for imposing a constructive trust, the court construes a trust. It implies a trust because we did not express a trust first. Okay. The expression constructive trust is absurd because constructive is derived from construe, not construct. The court construes the circumstances, it explains them. It does not construct them. Blacks, apparently from the Black's Law Dictionary. We don't express the trust, so they construe it to their benefit. Okay. Q trust is an implied or constructive trust. Social Security number trust account. It is a beneficiary of the foreign situs trust because you didn't express the trust after you age 18, right? So when we became age of majority, which is 18, we did not, basically we didn't take control of it. We had no idea, period. The Q is the remedy by which the court of equity finds justice for the one who has lost his property to one who does not legally have a right to the property. Before I go on, make sure y'all go watch the video by Christopher Hauser. It's called Lady Justice. And listen to how he breaks down the meaning of justice and what it really means when we are claiming that we're getting justice or we're fighting for justice or that justice is being served. I'm gonna just say this: justice comes from the word justia. Justia, it was a Roman pagan goddess, lesbo goddess. Okay, so when we say justice is being served, like when you say justice is being served in the courtroom or whatever, that's basically what they're saying. And he was breaking down. What he did was he went into the Constitution for Tennessee, because that's where he lives, and it was talking about how they are not to basically impose on people's faith, you know what I'm saying, whether they consciously know it or not. And so basically when you're saying justice is being served in the courtroom, whatever, they're basically imposing on your right to a religion or freedom of religion, pretty much, because you're basically unconscious of the fact that of the origin of the word. So this is how we get twisted up into all this crap, you guys, and worshiping.
Yeah, we've been bamboozled with the language that we speak, right? We don't even know the meanings of a lot of words we use.
Right. So I'm gonna keep reading. I just wanted to make that point there a little bit. It says, you are being construed as the one holding the property illegally. One is holding the property illegally when it has been acquired in such circumstances that the holder of the legal title may not in good conscience hold the beneficial or legal title, and equity converts him into a trustee. they construe the trust with you as the trustee under debtor or creditor law. You were supposed to pay, you didn't, so you are in breach of fiduciary duty. You can go to jail. Wow. Mm-hmm. You should express the trust with your intent under, say, equity or 1776 law form, which is pre-United States and pre-statutes and codes. So you then pay the private credit or negotiable debt instruments, NDIs, and you would be safe in making private payments with private credit. They put you under public policy where you have to pay with Federal Reserve notes. See what I've been saying, guys, pretty much all this week. Like, we think we're supposed to be paying with Federal Reserve notes, but we don't know the fact that, you know, anything that we sign our name to becomes a negotiable instrument, and it is basically looked at as cash at that point. Why is this doing this? Huh.
Yeah.
Okay. So, where did I leave off at?
Because everything you sign on, they can actually trade.
Right.
They trade it. Because, yeah, that's a negotiable instrument.
Yeah. I was just saying to Mother Shea Marie the other day, like, remember how before we used to write out checks, you know, from our little checkbooks, we used to rip it off at the coupon and send it to whoever. And they used to send it back to us, but now notice they don't send them back to us anymore. They send us copies.
Right.
You know,
before that, remember, I think before that we had carbon copy checks.
Carbon copy checks, right. Yes. And so now they keep it because our signatures are on those checks, they take those checks and recycle it back out and they use those as negotiable instruments. That's why they don't send us our ink wet checks back to us anymore.
Right. But just because you said you said they don't send them back, but they're supposed to, because another thing, when they send it back, it becomes a substitute check. So even if they that's what Brother Isaiah from the People's Remedy was talking about, even if they don't honor it when you submit it to them, when they send it back to you, that becomes a substitute check at the end of the day that you can still enforce and endorse.
Right. And that's why they send them back to us.
Because they used to send your checks back to you before, but they stopped doing that now.
Yeah.
Right.
They say they keep it in the archive, but you can request for it though.
Yes, you can.
If you request for it, they will send it to you. Yeah.
No, but we're talking about the ink wet check.
Oh, okay. Okay.
But the one that's got your ink signature on it, that's
right, the original.
The original are being sold on the New York Stock Exchange. So they take our checks and send them back out because since they got our names on it, they are now being used as negotiable instruments. So,
shiesty.
Right. So unless we request that, and I can guarantee you, go and request all those wet ink signatures of all your checks and request them back. I bet you they won't have them. They won't have them. They sold them. They got some things circulating on the New York Stock Exchange for the amount. So if I wrote a check out for $1,000, you know, for my rent, and I signed my name onto that check with real ink with my signature, that's gone. That's it's just like what they do with the promissory notes for the mortgages.
Right.
My name is being sold. They ain't gonna give you them checks back. They know what they're doing with it. Try to ask you for it back. Oh, it's in the archive. Why is it archive? I got my own archive. It's called the safe. Give me that. You know, they won't.
Right.
I bet you they don't have them.
So does that apply with cashier's checks too?
Anything you put
anything
your
you
name
sign,
on, signed with wet ink, yes.
Anything you sign.
Anything you sign with wet ink and use your energy.
Well, the reason I asked is because I you know, where I rented from before, like I would pay my rent through cashier's checks or whatever, and then I signed the back, and the lady, she was like, "Oh, you don't have to sign the back of it."
Mm.
Mm-hmm.
Oh, so they wanted you to give a blank check.
Because I thought that was weird. I'm like, you know, I thought that was so weird. I'm like, it's the thing on the back where you can sign it. You know what I'm saying? But she's like, oh, no, you don't have to sign it.
Yeah, because when you sign it on the back, it makes it to your benefit, not theirs.
Right.
Oh, so okay, because I was like, why? I said, why all of a sudden they don't want us to sign the back of the cashier's check?
Did you have a signature on the front of it?
They just put when I go to the bank, I say I want a cashier's check, made out such and such, and they just have my name printed on the front, but it's my signature is not on there.
But to sign it at the back, they cannot monetize it again for themselves. That's why.
Right. What you say, Mother Flora?
I said when you sign the back, they can't monetize it for themselves.
Right.
Yeah.
Right. So they can go ahead and put their bank stamp name on the back, and so all that goes back to them.
To them, exactly.
Right. Right.
Sign it.
Oh, okay. So sign it.
Yeah.
Okay. All right.
Because by signing it in front, they can go into your treasury account and take the money, and then they can also monetize it and still get more money from those who will buy it from them as a debt instrument.
Yeah. Also, when you sign from now on, Mother, when you sign and stuff, put all rights reserved without recourse on there.
That's what I do now. Anything I sign, I put that on it.
Absolutely. You said put what? All rights reserved?
All rights reserved without recourse. And I'm about to put this up and show you guys, but it's several ways you can sign. Cause I've been, like the universe been definitely.
Look, they got to be mad for real, cause I'm sure gonna sign it on the back.
Right.
What color ink? What ink pen should I use? Red, blue, black, blue.
Red for yourself. Red for if
Right.
It depends.
It do depend, but you can hold on. I'm about to put this in there. I just gotta load it up.
Isaiah said to sign it in blue ink.
Oh, sign it in blue ink. Sign in blue. Okay.
Yeah, anytime you're dealing with commerce, you sign in blue ink.
Blue ink, right? But when you
are dealing with your private estate, is
right. This is funny. Right. This is so funny because when I first joined the military, I like signing in blue ink because you don't know if people could make copies of your stuff or whatever. Right. But in the Army, they used to be like, you don't sign in blue ink. We not the Air Force. You need to sign in black. And I used to be like, why? And it used to just make me so mad. And now I know why.
With black, you can't identify if it's a copy if it's in black ink because
that's right.
Black ink.
Right. And that used to just
identify blue ink.
Yeah, it used to bother me so much. And I'm just like, what in the world? I'm like, these people being shiesty. Like they being real shiesty.
Do you know that even includes your rent when you sign a lease for your rent and you put the name on the lease and you sign it? That also becomes a negotiable instrument.
Yes, it does.
Sorry, when you sign your lease, what do you say it becomes? Where do you sign? When you sign it, say that again.
It becomes a negotiable instrument, and you can take that and turn it into your bank, but you got to set up the bank account correct first.
Right.
Okay.
And your rent will be paid at that point.
Right. You're supposed to be able to take your bills and everything to the bank, and once you got it set up, they're supposed to pay it for you.
Wow.
Here's I got put up.
What kind of bank account do you request for them when you set up this account? What kind of account do you receive?
Well, you're gonna go in there with your power of attorney, your DBA, all of that we
Okay, we talked about. Okay.
Yeah. You got to get the FDIC power of attorney. And have that notarized. And then you go to the bank and basically let them know you want to set up a private account.
So where'd you get your power of attorney from?
For the FDIC, you can get it off the website.
I think she means her other president.
FDIC, Gary of the FDIC. Okay.
Yes. Now, as far as the other power of attorney, Mother Mia has one that she has put together. She can, if she's willing to share with you all.
Okay.
I'm not on my laptop.
Okay. If you
possible the ones that because I was on my laptop.
Okay, if you don't have access, I can pull it up right quick and send it to everyone. Let me see.
Oh, much gratitude, much gratitude. I also sent the trademark copyright forms as well. So maybe that's something that they might want to take a look as well.
I'll send that to you all too.
Yeah, I remember doing a copyright for myself. There's a whole bunch of stuff. I wrote it out myself because I had, I was part of an online group that they were helping, you could create one for yourself. But I don't know where that is right now.
This is the one that
I start a new one. I start a new one.
This is the one that I sent out about 10 years ago. I took all my information out, so like read it really, carefully. But, I put it in red of all the places where you want to put what pertains to you. Just for everybody else who doesn't have a trademark copyright, I put that in. I sent that. And I also sent Mother Maria reception of signature.
Could you have a copyright as well as trademark your name? You can have both, right?
Yes.
Right, okay.
Yeah, I did a trademark copyright on the same form.
Okay.
Those are the ones that I sent in.
That's the POA. I'm just downloading the forms right quick, and then I'll send them over to you all.
Lord, it's a lot. It's a lot of information. I need to have me a checklist.
Yeah.
Mother, the book you are asking me about, the volume 2, is called The Art of Passing the Buck. And it's in 2 volumes. Yeah, you can go on their website. They like you to, buy it through them, but I've seen that there's PDF for both volumes online. So you choose. Actually, I'm thinking of downloading the volume 2 because the volume 2 is over $500.
Mother Flora, do you have a link to that?
Yeah, I'll put it on the chat.
Okay, thank you.
Yeah.
Is there a third form you sent me, Mother?
I sent you the POA.
Oh, the rescission contract.
Resign your name. So that's if you want to rescind. I put AAA 121112222. Just to say whatever your account number is, for whatever. Capital One credit card or, Wells Fargo home mortgage account number, you know what I mean?
Right.
So you're going to fill in what pertains to you. And on it, I will put where you need to put the straw man, but where you also need to put the natural person. And some of it says P/C because I'm not sure, who's going to. So make sure you read that part carefully and take out whatever doesn't apply to you. But that's for the most part. Because that's what the other one says. You want to start rescinding your signatures because we all know that all contracts are, like we just read, are colorable, and so they're all lies. They're all lies, and they are not. None of them are telling the truth. And so you can rescind your contract, that you send your signatures off the contract.
Okay, so I'm about to send these over to whomever wants. Mother Martin.
And me, please.
Okay. And Mother Flora, do I have your email?
Yes, you do. You sent me the document. You do, yeah.
The 5365?
Yes, that's right.
Gotcha. All right, they're on the way, ladies.
Thank you.
Share to non-Google account. Share anyways. Okay, gotcha.
So yeah, just read them over carefully. Take out what doesn't apply to you. Put in what applies to you, and don't forget to turn them all black when you're done.
Right. Yes.
Don't leave them red. Don't leave them red.
I want your whole thumb drive.
Oh, you don't want my thumb drive. My thumb drive, when I say I got 10 years worth of everything on it, it's very extensive.
No, I'm just kidding. But I know you guys are a wealth of knowledge.
Woo! Yeah, I got so much stuff. It's
yeah.
All right, ladies, we making headway. I'm excited about it all. So where did we leave off? Oh yeah, right here. It says if you have a drinking glass in the private, a title is used to represent that drinking glass in the public. Express trust is usually expressed in writing. Implied trust is created when you don't express it, and equitable remedy imposed by the court, the form through which the conscience of the equity finds expression against one who has obtained property by wrongdoing, or when the holder of the legal title cannot in good conscience retain the beneficial interest. Equity converts him into a trust. To understand trust, study the workings of the IRS tax code, the motor vehicle code, municipal courts, property taxes, etc., that which we have been induced into signing. I recommend The Law of Trust and Trustees, Bogart, and Scott on Trust, also Wills and Trust in a nutshell. So these are recommendations of books, I believe, if you want to write them down.
Mother, hold on just a second while I run and get my paper and pencil.
No problem. I'm gonna put it in the chat. Scott Trust and Wills and Trust in a. Okay, so those are the 3 books. I'm gonna copy it. I'm gonna also put it in the Telegram chat. I'm gonna put it in the comments for today's Zoom link. You guys should be you'll get a notification that it's been put in.
All 3 of those books are by the same author?
I don't think so, but it just gave the one author.
Okay.
I don't know. I'm not really sure.
No worries.
Okay. Law of Trust. Okay, there it goes. I'm gonna edit this too. All right. There we go. So it says, key points in trust law. He who claims trust must prove trust. That burden of proof is a prima facie case, the proof of which is in the expression of the trust. Mother Mia, are you back?
Yes, I'm sorry. Yes, Mother.
Okay, cool. I didn't want to keep going if you weren't back. Okay. It says, which in the expression of the trust, 4 elements to a trust. It must be parties, which are the grantor, trustee, and beneficiary. The second element is a specific res, property, or the thing. So whatever your property is, it could be you as well. And then 3 is the intent, and 4 is the purpose of the trust. It says trustee holds the trust property and is subject to equitable duties for the benefit of the beneficiary. They make us trustee or beneficiary by the mere acceptance of benefits. Beneficiary declaimer or disclaimer can waive or beneficiary declaimer can waive. So that's why he was saying to sign as a beneficiary. No one can be forced to be a fiduciary trustee only voluntarily. Did you understand that you were creating a trust when you signed that document? Is this your signature? One is presumed to know the nature and content of what he signs, but no parties to the trust, the grantor, trustee, or beneficiary need to know or understand that they are forming a trust. That does not negate the trust. Section 23, Restatement of the Law on Trust, and also on the Gilbert's Law summaries on trust, UCC is key. Incomplete instrument means signed writing, whether or not issued by the signer, the contents of which show at the time of signing that is incomplete, but that the signer intended to be completed by the addition of words or numbers. They add pay to the order of and $1 million. They turn the offer you signed into a check. You can do the same, i.e. turn it into a check. Instead of trading our labor for Federal Reserve notes, we have to learn to trade our credit for them. Trusts are formed by 1, transfer of the res to trustee, who is neither settlor nor beneficiary if the transfer or expresses simultaneously with or prior to the creation of the trust. Transfer is another portal termed under UCC sub 200's negotiation. A transfer is by one of 4 methods: endorsement, delivery in bearer form, assignment on a UCC 3, and also by operation of law. But a transfer is also a trust term. A transfer using one of these methods forms a trust. A declaration in writing by the owner of the property that the owner holds the property as trustee for the owner and another person as the beneficiary. 3, appointment assignment. If the beneficiary makes a prima facie case, the burden of contradicting it or showing a defense will shift to the trustee. Let me read that again. Appointment assignment. If the beneficiary makes a prima facie case, the burden of contradicting it or showing a defense will shift to the trustee. Bogart discusses how there is a certain ill-defined threshold the beneficiary must prove. Then the burden shifts to the trustee to prove that he met his responsibilities. He has no evidence he can prove unless he made the payment. Why would a beneficiary make a claim if he got paid? And 4, by contract. Let's see. The art of passing the buck. Oh, okay. Thank you, Mother. The one who is able to prove the expression of the trust elements and has the burden of proof to do so. If not proven, there is no trust. In commerce, the trustee is presumed to be guilty. The one who is able to prove the expression of the trust, U.S. versus SNEP, wherein the U.S. CIA sued SNEP because he had 2 non-disclosure agreements with the CIA to not publicize data. They sued him under trust law, not contract law. If there is an absence of a fiduciary, a court may appoint one. Equity will not allow a trust to fail or lack of a trustee. Acceptance of benefit is presumed under Bogart 169. All number references following are also from Bogart 191. Acceptance is presumed. There is nothing you need to do formally to become the beneficiary of these scams. The beneficiary made this claim under 170 to 72 and 170 to 205, where conduct by beneficiary, including silence, amount to disclaimer, a refusal to accept the gift of the equitable property right. Since acceptance is normal, a claim of renunciation must be supported by clear evidence. Disclaimer in nunc-pro-tunc, now for then, which means now and for then, to the start of the agreement. Okay, so basically that's what you need to put on your disclaimer. 172 at 227 to 228. Conduct by the beneficiary, which is inconsistent with his benefits, may amount to an implied disclaimer, and statutes which require surrender of trust will be in writing do not apply. Since a surrender is based on giving up equitable interest, this is the unknown beneficiary problem, which can be your defense because the alleged trustee has no obligation to pay. How do you make a prima facie case? Simple. Come in with all the documents copied and make an allegation. Beneficiary must show he is a beneficiary managed by fiduciary of a trust with a trust res. In other words, express the trust. Where the beneficiary is unknown, the trustee has no obligation to pay. When they construe you to be trustee who hasn't paid, what would your defense be? The unknown beneficiary, since the trust, let me read this. In other words, express the trust. Where the beneficiary is unknown, the trustee has no obligation to pay. When they construe you to be trustee who hasn't paid, what would your defense be? The unknown beneficiary? Since the trust was not expressed, how would you know who the beneficiary was? Or you could re-express the trust to your liking with yourself as beneficiary. Identify the party that needs to be paid, 161 at 133 or 134, breach of fiduciary duty. So basically they're breaching their fiduciary duties. They're end of the contract. They're not holding it up. So you can basically, in so many words, sue them if they don't do what they say, but you have to express the trust first. Breach of fiduciary duty can put one in jail. Misapplication of fiduciary property or property of financial institutions, embezzlement, misappropriation. 18 U.S.C. 371, defraud includes embezzlement. 18 U.S.C. 371, conspiracy to defraud the United States. The General Conspiracy Statute, 18 U.S.C. 371, creates an offense if two or more persons conspire either to commit any offense against the United States or to defraud the United States or any agency thereof in any manner for any purpose. The trustee may deviate from the terms of the trust if all beneficiaries agree to that. Scott's on abridgment 216. As an example, let's say there are several beneficiaries and the trustee wanted to make a donation to an organization which is not listed as a beneficiary in the trust. If all but one of the beneficiaries support it, the trustee cannot, if all but one of the beneficiaries support it, the trustee cannot. It must be unanimous. Polk, who was the beneficiary, versus Farmers Trust and Loan, 157 U.S. 429, 1895. To reconvey the mortgage, you must terminate the trust. When you signed the application for the loan, the bank monetized your signature, got paid, deposited into an account. Then you signed the promissory note at closing, which they deposited onto the right asset side of the ledger and deposited your security agreement on the left debit side. No debt validation. Then get them in dishonor. No debt validation, then get them in dishonor, which we use for revoke of power of attorney. Re-express the trust with appointment of trustee equals bank. Since they are the beneficiary, the trust terminates, but because they can't be both. Right, they can't be the trustee and the beneficiary, but they benefiting with their bitch asses. Excuse my French.
I'm with you, mother.
Right, it's right. She's right. Since they're both the beneficiary, the trust terminates because they can't be both. Right.
Right.
So you can't sit there and say, "Oh, I'm the trustee, but and I'm the beneficiary." No.
Right. Right.
No, you can't benefit because then that's a conflict of interest. So you the trustee. It's like you being the trustee and taking money and putting it into your own account for your own use. That's theft.
Right.
Double dipping. Yeah.
Double dipping. Yeah.
And it's fraud. So you can't, it's just like with the banks. You can't sit there and have the banks as a trustee, but then they're also the beneficiary because they're taking your money.
Yeah.
Like, no, you can't be both. If you're gonna take the money, if you're gonna be the trustee, you can't take our money too. That's just a no. Like Mother Shea Marie said,
So it says, now the trustee must disperse funds to the beneficiary. As grantor, you instruct the trustee they're in breach. Debtor creditor law is where you're paying for 30 years. Establish holder in due course status. Follow UCC procedure, which we're not going to do, but this information is still good. C, agree with your adversary quickly. Template, acknowledgement of debt letter. Oh, these got links to them? Oh, shit. Oh, wait. Oh, wait. Oh, shit. Okay, we got links, y'all.
That's awesome.
Agree with your adversary. Agree with thine adversary quickly whilst thou art in the way with him, lest at any time the adversary deliver thee to the judge, and the judge deliver thee to the officer, and thou be cast into prison. Providing information on how the SECU trust was formed and the trust has gone dead, and they are construing the trust and operating the trust without you. With this material provided you can straighten this out as beneficial owner and with ultimate controlling interest. Boom on their ass. So these are just documents, template, accept the charge letters. So let's see what this is. It says certified mail, letter of acceptance of the charges. Oh, this is to be sent, I think, when we got to read over this. Please take note that I have accepted the presentment made by name of prosecuting attorney to John Doe for assessed value and returned it to the presenter in exchange for closure and settlement of case number. I have exchanged my exemption for a discharge of the charges. I enclosed an authorization form for him to use my credit to discharge all court charges that may apply. The instructions and a statement of the account were attached. The Treasury has also been notified that I am using my credit for this. Y'all, we about to be on and popping. Let me see what this other document is. Acknowledgement.
That's what I was saying, that no matter what, the Treasury has to be notified of what you plan on doing.
Yeah, you did say that.
Yeah, and I think since I have an RR number, return registered mail number, I think I didn't put that number on there because the card did come back to me from the Treasury. So they did get it, you know.
Okay.
But I also know that I didn't, you know what? I sent it to 1500 Pennsylvania Avenue, but I didn't do my state Treasury. I didn't do the state. And I should have, you know, I should have sent it to, I still can actually send the copy to the state Treasury as well.
Wow. So this letter says, letter of debt acknowledgement. The undersigned hereby confirms and acknowledges to the lender or corporation name that strawman, put your strawman there, is indebted to the corporation. The undersigned hereby accepts the debt in the amount of, as of date hereof, which amount is due. And yes.
And beforehand, you guys also with the certified mail and RR registered mail, you can also get those from United States Postal Office. And
oh yeah, I got some.
A roll of register rolls. Yeah, they'll send you those for free.
It's the red. You guys know you need the green card, and then they don't like to give them to you. I actually had to go like in the suburbs because the niggas here think that it's theirs and it belongs to them. So they be the police and the stuff like it's theirs. So I had to go.
And they'll send them to you.
I tried that, but I never received them. So I don't know what that was all about. Okay. I had to go get them.
Oh, okay. Because I received mine, but maybe I don't know.
That's the registered. You're talking about the registered labels, right?
I use the green and white one.
Okay.
And the other one is green and white, and the other card, the registered one, that costs like a whole lot of money. Those are all green.
Okay, so you're not talking about this, the registered mail stickers. They come in red and white.
Let me see. Go down for a second. Yeah, okay, then maybe there was, but mine was all green. Oh, okay, that was the card that was with them that you get back. So there's one that when they stick it on the envelope, they rip it off, and then when it's got layers to it, and then when you, because mine was registered return, which is the RR.
Okay, yeah, I know. You talking about the green card. I have some of those, yeah. But do you use these at all, the registered mail labels? Because
I always use the register return because I want somebody to sign the card saying that they received it, and I want it sent back to me as proof that they got it.
Okay, because when I did my, I'm gonna just say when I did my A4V process, the process that I was taught was to when you fill out the actual document that you're printing out to send to the CEO. You put this in like up here. I think this is what this is talking about. Where'd that form go? But it could be certified mail, but I was told to use that red one. So that could be another reason why I wasn't accepted. Because I was told to actually put this on the top, in the top right corner of my paper. But I did
of the actual letter that you're writing to them.
Yes, of the actual letter. But I did use the green card too.
Because you could do certified mail, because certified mail is not as much as registered, but it's still making sure that it's guaranteed to get there.
Okay. Cool. So I was just reading through this letter.
And then you put the letter. So when you have it in your possession, once you pick out which one you want to send, you put that number up in that corner, and then you mail it in.
This is the rules of signature. How was the beneficiary trust? I'm sorry, Mother, you had something?
No, it's okay. I was just looking at the way they signed the, yeah, and I found out that the way to sign your signature is, especially with it. Yeah, it's, yeah.
That means you're the flesh living blood. That's basically letting them know, like, here, hey, I'm here. I'm not dead, motherfuckers. Oh, so it says the rule of signatures. How was the beneficiary trust created? Your signature authorized it and granted the existence of the trust. The SS5 application was for the Social Security number account. The signature that you signed with, was it qualified or unqualified? Most likely unqualified at that time. So the trust was formed and you didn't say anything as the beneficiary, and the trust has gone dead basically, and they are construing the trust and operating the trust without you. You need to go back in and straighten all that mess up by making another re-application and give the qualified signature on the application. Yes, as long as I have the 4 elements and 1 method of formation, I can prove that I have been done SS5 application. That is proof you are the grantor because you signed and you brought that number into existence. That trust account per your authorized signature as grantor, then sign the beneficiary card as beneficiary and signature, and make copies of that and send them copies of what you did, your signature, and now you've notified them according to due process. Recommended private sector autograph. Always right hand justified in blue ink, thumbprint in red ink. Private sector autograph. So it's all rights reserved by authorized representatives. Then you put your family name, which is your last name, dash, your first name with the dot, and then your middle name. Wait. I'll take that back. This is your first name. So your first name, I'm sorry, guys, your first name dash your middle name, and then the colons with your last name. And then you sign under duress without recourse. Now you have the proof of the original that you and the grantor and the beneficiary on that Social Security straw man trust account. What we're leading to is, for example, in a mortgage, we start out with a promissory note, which is really a title. They want your signature to gain access to your exemption account, which is the SSS account, the SESTQ trust public liability, which is drawn against the foreign situs trust, the birth certificate BC trust, private assets, accounts must balance. So the promissory note is just a decoy so that they can grab your signature and add words and numbers to it. The key is, how did you give your signature? It is the rule of signatures and the rule of forms that count. You never want to give your unqualified signature in the public because it is going to be construed as the straw man. That gives them accommodation signature rights, carte blanche, and access to your accounts. You can restrict your signature so that you have access to the account. You want to sign before signature and put by, and then your title, which is grantor, by, or put by trustee or by beneficiary. The 3 parties of a trust or sign as authorized representative. I call the AR the portal term because it portals into your UCC. Under UCC 3-402, where the authorized representative is signing for the contract debtor or creditor relationship, it does also apply to trust with a Form 56 appointment to the authorized representative who may function as co-trustee. Special conditions apply for the authorized representative because now with that appointment, he's under trust. He can operate as assistant to trustee and can also be the trustee's assistant as the payer of the bill by the private contracts on the Form 56. Without it, he's under UCC 303-402. Authorized representative could be either debtor, creditor, context, or trust. The SS account trust is really a sub-trust, and by giving qualified signatures, that tells them you know who you are. If you do not express, I'm sorry, where was I at? Okay, little baby. Okay. By not expressing the trust, we drop the ball. They pick it up and construe it in their favor, with you liable for payment with Federal Reserve notes as a 14th Amendment citizen, liable for statutes and codes.
Can somebody else do the reading while you sit to the baby? I can continue with the reading.
Most definitely. Thank you. I appreciate you.
Okay, where are we again?
I just stopped.
The SS account trust? Or
I started right here, this paragraph.
By notes, okay.
It's my mother's. Before you begin, I do have to get going so I can get ready for my class.
Okay.
But Mother Saint Marie, are you gonna put this here? What we're reading from in the
I forwarded it, so I hope you guys can see it. I did forward it into the Telegram chat. Just gotta click on it and download it. And then these documents are from the book. And then it's this red writing. You click on it, it'll take you to those documents.
Okay, and I'm sorry, and which book were we reading from? Now, where did we do we have the book on the Google Drive or?
Well, I didn't send it to you guys. I can't send it. I think I sent it to you, but this is Learn to Express the Trust, which I put in the Telegram chat. So you guys got to download it.
Download it. Okay. That's what I wanted to know, because this is more study material for me. I love it.
Yeah, that's more study material. This one seems more, very explanatory.
Right.
Yeah, and easy to navigate.
Most definitely.
Because I have a lot of these, but it's good to see how, other people's thought processes is when going into this. And I like how they included the trust.
Right.
Yeah.
So that's good how they're tying it in. And although we're not going off of UCC, it's good to know this stuff anyway.
Right.
So we can at least know the law, even if we don't.
Yeah. I like the way he talks about the nature of the rights of the cess to create trust. Yeah. That's good.
I have to get going. Thank you so much. It was a really good book reading today. And
thank you, Mother.
Yes, and we will, and if I come across anything else, I'll definitely let everyone know. Okay, yeah, because this week I'm going to be doing the whole bench, and I'll let you know how it goes.
All right, look forward to hearing it all.
Dad, are you going to see me say "Fight the Power" on TV?
Right.
Okay, Mother.
Okay, Mother, take care.
Okay, Mother, take care.
See you in a little bit. Yep, see you soon.
See you soon.
Okay. So we can just finish up a little bit more reading. Maybe we'll cut out at 1 o'clock. Is that fine with you all?
Of course. We've got mounds of information.
Right.
Yeah.
Mounds.
Yeah.
Back to where were we just at? We were on the rules of what were we just at? Of the signature. I think right here. So we're almost done reading this form.
Yeah, that by not expressing, is that where I'm going to start? By not expressing the trust.
Mm-hmm.
Okay, by not expressing the trust, we drop the ball. They pick it up and construe it in their favor, with you liable for payment with FRNs as, let me put my glasses on, sorry. Here is a little bit dark today. Okay, I have it. Yeah, for payment with FRNs as a 14th Amendment citizen. Liable for disputes and codes. If you express the trust, you can make payments with private credit. As you function, you're going to have to give a key restriction to correspond with the duty you are performing. That is going to be looked at and compared with what you are trying to accomplish in comparison to how you're signing. Unless the key fits in the door, the key won't open the door.
Yeah, I'm in the bath today.
Rule of signatures defined. And then the website for that, you can go to that and read it. And it says, see also the forms, the rule of forms, keep the original.
I'm sorry, I think I muted you, Mother, because there was some background noise. I was trying to mute someone else.
Okay.
Yeah.
Says, yeah, make copies to give to them. Keep the originals except for promissory notes, payments and such.
All right. I think that's
is that it? Or
that's the end of that document. So let's try to pull up this one. Moving titles in trust functioning as commerce. Right. So this is basically showing the difference between the two sides, I believe.
Mm-hmm.
Birth certificate and a live birth record. So we don't have to read that, but we're gonna read this right here.
You know, with your new granddaughter, you don't have to do a birth certificate for her. You can start getting the next generation doing the right thing from the beginning. Isn't that awesome?
Yes, it is awesome. But let me tell y'all what happened, and I'm really pissed off about it, but we can get it rectified. It's not a problem. So you know, my daughter, when she went into labor, it all happened so fast, but before she went into labor, we had already been trying to you know, look into getting a possible doula or what do you call the birthing assistance people, a doula?
Yeah.
Midwives, yeah.
Midwives.
So, you know, it's kind of expensive. So I found someone who turned me on to, you know, some paperwork that you can fill out. You have it notarized. And when you go to the hospital, they have to basically honor it when you hand it to them. So we were rushing to the hospital. And I told y'all before we weren't even in the hospital 5 minutes and the baby came out.
The cable came. Oh yeah.
Yeah. So when we walked into the desk, I handed the nurse with a lady behind the glass the documents. And so my daughter was like, oh, she coming or whatever. So they took her to the back of the room, and I was still in the front desk. At the front desk for like maybe 1 or 2 minutes, and then they came back and got me when I went back there. Like she was literally having her. So by the time she done came out, and she came out and they were trying to clean her up, but they just moved her to her official room because she was still in like the triage room.
Mm-hmm.
So they're cleaning her up and stuff, and I look over to my right and I realized that the documents is on the motherfucking couch in the room.
Oh
yeah. So I looked at my daughter, I'm like, why these forms right here or whatever? There was a midwife that actually came in there. She came in and she was a melanated woman. So she cleaned her up, and we were instructing them, we want to keep the placenta on. We were on it, trying to be on it, but you know what I'm saying? They also distracted us where I wish we were more prepared because the document never got enforced. So she did end up, like my daughter, she told them she didn't want none of the tests done. She didn't want, she told them she didn't want her to have any shots or anything like that. So they were honoring what she was telling them. But do y'all know that the motherfucking CPS people showed up here a couple of weeks ago, like last week?
Who are they? CPS? Who are they?
Talking about one of the nurses from the hospital called with all of this other stuff. And I was so mad because I'm like, that document should have got enforced. They were slick about it.
Yeah. They knew what it was. That's why they left it on the couch.
Right. I'm so mad.
And that's why they reported it, so that they can, What did those people say then? What did they say to you when they came to you?
Well, I was telling them my daughter wasn't here. They were just trying to get all up in the business at that point. So she called back and made an appointment to allow them to come the next day or whatever. They were just saying like some of the, she was saying that what was reported is really minute, but we just want to make sure the baby is fine. So I'm like, well, the baby is good. They like, well, is she here? And I'm like, no, she not, but the baby was here. But I'm telling them like, she not here or whatever. This was the day they just came showing up at my door. And I was already feeling like something was about, because I kept looking, like every time I hear something, every time I hear a car door or something shut, I'm looking out my window because I've been feeling like something about to happen. So I've been on it because somebody showed up the day before, just pulled up in front of my house, and they said,
they're watching because that similar thing happened to my friend in Florida. I think her daughter her granddaughter is, I think, 13 now. But I don't know what happened to her daughter, and she ended up in hospital, and she was blotting out a lot of stuff which they were writing down. So she had to move to the mother's house for a bit before, because the mother had to get her back to herself. And these people, just like you're saying, showed up at her doorstep, and they said, I think they wanted to get the child off of them. So what happened was my friend, the grandmother, took the child, because she took the child to one of her friends to stay while they deal with the official and while they deal with the legal stuff. So they don't even have their child living with them. So now, because she's taking classes, she's trying to put documents together and nationalize herself and her family, so that the state cannot take the child off of them. Can you believe it? Oh. Yeah, because they feel that it is their property.
Yeah, they just trying to get in your business, because they talking about, well, we just want to make sure the baby is sleeping in a safe location or whatever. I'm like, if y'all go in my grandbaby room, my daughter room, like her whole room is the baby now. Like, my daughter really took her time and made sure the baby had everything. And then from the baby shower, she had more than enough. So it's like, this baby is good. It's none of y'all business, really. But
the thing with that is they act like we don't know how to take care of children. Hell, who's taking care of their children for them?
Right.
Yeah, exactly.
Now this is so sinister to me, you know. I mean, they're really trying to kidnap people's babies. It's really what it is.
The reason why they do that is because they get paid. They do get paid by as many babies they get away, and they take away from their mothers. They get paid. The state get paid.
Was your daughter able to keep her placenta?
So they kept telling her that everything had came out of the placenta, so it was like no reason to keep it, because the nutrients and stuff like that had already came out. Because I told y'all my daughter had the baby on her knees or whatever. She pushed her out on her knees.
Yeah, but you could have taken possession of the placenta, because they sell the placenta. Because
they do sell it, but we didn't have like the proper storage for it and stuff like that. So she just let them detach it. At that point.
Usually what they do, I know back in Africa, they usually put it, they bury it in the ground.
Because they were saying, well, we just gonna toss it in the garbage or whatever. So
they lying.
Right. My daughter was just like, okay, because my daughter, she not really confident yet in this knowledge either. So you know, she's only 18. So they kind of got kind of scared because her and her boyfriend, the baby's father, when they was at the hospital, they like, well, they trying to get me to sign for this, for the birth certificate or whatever. And I was like, well, what are you going to do? You don't have to sign. And so her boyfriend was basically like, just sign it because they ain't want no troubles. Like, because if they started giving them trouble, then I know the baby daddy was probably going to go the fuck off in that hospital.
My daughter did the same thing because I was telling her, she's a doctor. I mean, she's a lawyer herself. She wouldn't listen to me. I told her not to register the baby's birth. She said, you know, she didn't understand what I was saying to her. She wouldn't understand. But so I guess none of them and the husband, the same thing. They don't understand any of those things. But I know that in time, when I get all my stuff set up, you know, I can revoke that. I can revoke. And of course, I'm going to make sure that I tell my granddaughter everything. So even when she's 14, she can take charge of her birth certificate herself.
That's right. That's right. Because that's what the Jewish people do for that's what the bar mitzvah stuff is about. Remember I told you about that before? You know, at the age of 13, they take their child and they start teaching them this stuff. When they become age majority at 18, they'll already know what to do. And this is what we missing. This is exactly what we missing.
They have a guy on YouTube. He talks about that all the time. I don't know.
And the reason why our children don't listen to us is because we send our children to their schools and then they get brainwashed. Whereas the Jewish people have their own schools.
Right. So for the most part, my kids listen to me, but they're not taking the time out to study and learn for themselves like they should be. So it's like really all on me right now. So until I think once they start seeing me have more like you said, more results, getting more results and stuff.
Yeah. That's what I said to myself too. Once I start getting results, my daughter will listen to me, because sometimes when she doesn't listen and she has her own situation, she asks me, she will do what I ask her to do. Yeah. But until then, I just say, I don't say anything to her anymore. I just do my own thing. Once you get results, because people like to see results.
Right. True.
Especially with the traveling thing, I think, when you've done your stuff and you're able to travel back and forth without taking this damn vaccine, they say, I think people will start listening to you.
Absolutely.
My sister, they traveled to, they lived in London, UK, and they came to the US this past week. They're in Florida right now. And my sister said, the stress of traveling, oh my God. She said it was just a lot of stress going through, just getting to the US from the UK. And then they're off to Texas, Houston, Texas on Tuesday, where my mom is, my brother.
Wow.
Yeah. Okay. But they've taken the jab. So they've taken the jab.
Wow.
They're still having problems. And then she was telling me they've passed a bill in the UK, but they're trying to pass a bill whereby they can strip people of their citizenship without their notice.
I was reading something today talking about it was a video. I didn't watch the video, but I read the heading of it talking about all states are no longer sovereign states or some shit. I'm like, y'all are fucking lie. I'm sovereign, whether y'all want to acknowledge it or not. But it was saying somebody announced that all the I gotta go find that, because I was supposed to watch it, but I was trying to do some other stuff. But yeah, I want to get through this last document right here, and we're gonna end for tonight. For today, you all. So I think this is important to go over right here, this little piece. It says, maxim of law, he who fails to assert his rights has none. So this is the difference from a birth certificate and a live birth record. So birth certificate is a title created by the state. A live birth record is title created by life. The birth certificate, it is cargo or birth or delivered. The live birth certificate is baby born or endowed. On the blue side, it's informant. So the mother is the informant who autographs an indictment that you have no paternal holder of your estate. On the right side, it says your mother autographs to establish that you are holder in due course of your estate. On the left side, register signs your estate into probate. On the right side, mother gives maiden name, which indicates a bastard, later stillborn, on the register. On the right side, on the left side, yeah, it's crazy. I wonder what bastard, let me look that up. I wonder what they are meaning, because you notice there's several definitions.
So you want you mean for bastard?
Yes.
Well, yeah, I think it's somebody that is born outside of wedlock. It's what people refer to as bastard. That's the Bible definition anyway, but there could be more definitions to it.
He has got several right here. So a word derived from bas or bast, signifying abject or low base, and ard, nature, infant, debase, a child of low birth. I don't like that. A bastard in the lost sense of the word is a person not only begotten, but born out of lawful matrimony. Okay, I can get with that. This definition does not appear to be complete in as much as it does not embrace the case of a person who is the issue of an illicit connection during the coverture of his mother. The common law says the mirror only taketh him to be a son whom the marriage proveth to be so. A man is a bastard if born first before the marriage of his parents, but although he may have been begotten while his parents were single, yet if they afterwards marry and he is born during the coverture, he is legitimate.
Yeah, but the thing is, though, there is no
so it has several definitions.
Yeah.
But you just have to know how to use
just societal that is just societal what do you call it? Acceptance of, but in nature there is no bastard children.
Right.
There is no bastard children. So yeah.
Okay, moving along. It says name is registered. A legal trade name is publicly registered, combining your given and family names. An appellation is given. A lawful appellation is privately recorded, inter vivos, traditionally in a family Bible. So yeah, I've looked up a family Bible on Amazon. So I got that in my cart to be ordered soon. Estate trust is the trade name. Estate title is the appellation. Format is typically all capitals on a vessel gravestone with a fictional title, i.e. Mr. John H. Doe, but can be any first and last name. Format is proper grammatical English for the appellation, with your upper and lowercase name, John Henry, i.e. John Henry, of the family Doe, or the unique given estate title, John Henry. On the estate trust, on the left side, the capitis
Diminutio maxima. Thank you, Mother. The highest or most comprehensive loss of status, charged from one of freedom to one of bondage. John Doe, Black's Law, 2nd edition. On the right side, under the estate title, the capitis diminutio minima, the lowest or least comprehensive degree of loss or degree of loss of status, rights of liberty and citizenship unaltered. John Doe. So your foreign situs trust, which is on the left side, boo-boo side, formed by legislation when an artificial name is registered in the law of the sea. The trust splits your estate, all property, into a legal title, right of possession for the state, and an equitable title, right of use for you. On the right side, the heavenly side, created by the parents of a living soul when a given name is gifted in the law of the land. At 18, you can claim the legal title over your estate, all property, by becoming the executor or executrix for the foreign situs trust, which is your name or appellation. So back to the blue side, this is a temporary trust because you can become holder in due course of your estate. On the right side, this is a permanent trust because you have a lifelong right to claim title of your estate. On the left side, equitable owner with users' equitable interest. On the right side, beneficial owner with ultimate controlling interest. Person on the left side, the person name is a debtor, liable for debts, surety for corporate debt. On the right side, a man is a creditor and can create wealth and has power of remedy. So we can't create no wealth when we're debtors, period. Debtor on the left side is trustee, taxpayer, resident, voter, limited, residence, income, address. On the right side, it says creditor, executor, grantor, national, elector, unlimited, abode, remuneration, or location. So these are all titles that benefit you on the right side. On the left side, it says this certificate is a certification of a bond with the World Bank as settler of the trust. On the right side, this record is used as evidence for a birth certificate that certifies a bond issue. On the left side, the original bond becomes a security that is traded on the market for your value, or on the market for your value. On the right side, it says includes your birth weight in ounces used to calculate value in tables related to gold. On the left side, you are a foreigner, vessel trading on the sea of commerce under admiralty law of the sea. On the right side, you are a sovereign man and woman born free of the land and living in the common law of the land. On the left side, this registration converts your estate into the tradable property and puts you to work for the foreign situs trust via the name. On the right side, this record documented your estate, which then can be stolen, but is also an affidavit of life and proof of claim. On the left side, title claimed by state, meaning your title is claimed by the state, false presumptions, claim, and contract. Inherit rights to title you will have on the right side, potential holder of your sovereign estate. Mother, if you don't mind reading this little piece, and we can continue on. Okay.
A little feisty.
Moving titles in trust. claiming and moving trust as a remedy, functioning as commerce. Concise explanation all about claiming and moving trust as a remedy. Talking about decoding trust in the book, Gilbert Law, Summaries. Trust by Albert C. Hallback, Jr., and looking up the words in Black's Law Dictionary, first edition. It's all about trusts. A gentleman asked a question earlier, and I would like to explain. Everything I've been doing in the past, I have realized it was debtor/creditor, and I realized that we were doing everything all wrong and backwards. I really changed my whole focus. Everything is completely different now. I am gearing everything towards trust. It really makes more sense. Once you get into trust and study trust, you find out a lot of what didn't jive under debtor/creditor. All of a sudden makes sense under trust. I'm switching everything into the trust mode. Instead of doing debtor/creditor, I am going to stick with trust. I'm going to live, eat, and sleep trusts. I'm leaving the debtor/creditor behind. Not that I might never use it as a hybrid, but you really can't get a remedy as secured party creditor. Your remedy is in trust, and it's commerce through trust and equity. In a trust, you are the lender of an asset held in special deposit, and if you don't express the trust, you are the debtor under the UCC debtor-creditor relationship. You will have to bond the case, and the bond is really with the trust. A bond is a trust in a trust relationship. Here, we have been talking about trust all along, but we've been construing it along with everybody else because we never expressed it as a trust. So they are construing it and getting us to function under debtor-creditor. Under UCC, accept for value/return for value and everything like that. We have things in trust that are similar to those, although I wouldn't call them accept for value. It's all really explained in Gilbert Law Summaries. Trust as a basic primer for statutory trust, which is really the black. The trust that we really are talking about is the white trust, which is opposite the black. But if I teach what the black is, you know the white by sight. To give an example, the AFV/RV, the accept for value/return for value under debtor-creditor, which is in my opinion, and the evidence I have discovered, which is not, which is not debtor-creditor, which in my opinion and the evidence I've discovered, which is not exactly strictly opinion. What we were doing by AFV/RFV was creating a lien, which was under UCC, which was a negotiable instrument, and anything under negotiable instrument law is debtor/creditor, and you are creating a debt. A debt is what we are using as money in the system today, and it is functioning as credit. Credit is what we use as money. These liens that we are creating, that we were putting our unqualified signature to, which is the rule of the signature that I go by in expressing the trust. But since we are not expressing it as a trust, we are creating a lien. So what we are doing is just making a bigger debt to pay another debt. We got double debt upon debt. They love us for that because we are creating more money for them to utilize. Here, all along, we thought we were getting some kind of set-off. And we weren't even touching the set-off on the private side. We weren't doing a discharge on the public side. We were just adding to the debt, a public debt. It is my conclusion that we no longer need any AFV/RFV because there is a better route. That's why what we did in back then didn't work, using that AF. And right. that route is 180 degrees the other direction. I think that is what they were using to lead us down the path by giving us a few bones here and there of successes, because I don't know anyone at all who can claim a 100% success rate on any methodology that they use out there. No matter from A to Z, where it was, litigation, redemption, OID methodology, everybody has a success rate of about the same. That made me wonder why. Why is it that it looks like you could through a garbage can lid in there and get a remedy to some degree, when somebody could take somebody's success and duplicate it exactly the same way, and they don't get a success? That made me wonder why. I did the same thing. I was wondering why too.
Same thing here. That's why we've been saying if it worked for one, it should work for all.
It should for others, yeah.
Right.
Okay. Then with this trust stuff, I was studying all along. The more I studied trust, my eyes got opened up to the fact that, hey, it's been trust all along. All of us has been talking about trust, but we have been talking about trust only in a protection method for protecting assets. That was just a device for protecting assets of the debtor from the creditor attacking him. We want to put it into trust, treating trust not as a defense move, but solely as an offensive move. I've been finding out that's what they have been coming at us with all along. It just looked like debtor-creditor, because debtor-creditor and trust relationship are so closely related. They look similar on the surface. When you dig down into it, you will find out they are a little bit different. When you find out trusts are operating in a totally different world, in equity, and here we thought it was admiralty all along, which is nothing more than debtor-creditor. They were taking you into admiralty to force you into breach of contract. But really, there can't be any contract because there is no money. You can't give a value for consideration. Under trust, you don't have to give a value of anything. It's a thing. Whatever the thing is, the Rez, that is what is put into the trust. That's the principle. That is the property. That alone should tell us something. The fact that most of us were getting the debtor-creditor relationship is so closely related to the trust that you have to dig down into a little bit. Plus, it operates solely in equity, and that is where the trust power is. That was like the admiralty coming at you under debtor-creditor, which was operating and taking you into equity. and then for the enforcement. Then you got the breach of the duty under equity, because equity is not compelling you to do the duty. When you didn't do the duty, you wound up in jail, or you owed a debt and they foreclosed. Really, it is the same as the trust. What we thought was admiralty or debtor-creditor was really trust. If it walks like a duck and talks like a duck, it's a duck. We are talking about the actions of a trust. If it walks like a trust, talks like a trust, then it is a trust. That's the whole secret. No parties in the trust need to know they are forming a trust, including the grantor, the trustee, and the beneficiary. That does not negate the fact that a trust was formed. If the law recognizes a trust, then there is a trust. As long as I have one of the following elements: intent, purpose, parties, or specific res, then I have a trust. As long as I can prove that after I've made a claim, then I have standing to come in and make a claim as a beneficiary and say that the trustee didn't make a payment or disbursement. When I prove that I have formed a trust, then I have a prima facie case against the trustee. A court of equity assumes that the trustee is guilty. You know, this just brings up an idea for me to claim my, what people owe me. Anyway, prima facie adjective sufficient to establish a fact or raise a presumption unless disproved or rebutted. Black's Law Dictionary. That is exactly what they were doing when they took you from admiralty into equity. The same thing happened there. The strength comes in equity, where the court is going to assume the trustee is guilty, didn't make a payment, and the only way that the trustee can prove that he is innocent is that if he has a record that he made a payment. The only thing a court wants to know at that point, when are you going to make a payment? If you are not going to make a payment, then you are in contempt. This is where the power of the trust comes in. It is in equity. Here, all along, we were talking about a trust operating in equity with a different face mask, thinking it was debtor, creditor, or admiralty. And it was not. They are tricking us to come under debtor, creditor, under UCC, creating these negotiable instruments, thinking we are going to do a setup for discharge, and there is no way possible. How does one get a remedy then? Even though the remedy is not in the creditor-debtor relationship or the secured party creditor, the remedy is in trust, commerce through trust. It's not that you are a secured party creditor. It has nothing to do with that. That is going in the opposite direction. Knowing who you are as grantor is the important part. For example, if you are the grantor of the trust or the beneficiary, or maybe the grantor and the trustee, then you've got different powers through the parties. Whichever way you want to play it, the key is whoever is the signer on the instrument, that was the grantor of the whole thing to begin with. That is where it all began. If you didn't express it to be a trust from the beginning, here it was a trust because there is no money, and everything has to be a trust. When you go to the grocery store to buy groceries, you think you are paying for something with Federal Reserve notes, and that is just your purchase. You aren't purchasing anything. You are forming a trust. The same way at the gas station when you buy gasoline for your car, you aren't buying gas. You are forming a trust.
I'm sorry, Heather. I just want to reiterate, because this is what I've been trying to get people to see all week, is that even when you're using cash, it's a negotiable instrument. Just like the Federal Reserve notes, it's a negotiable instrument. So it's the same thing. You're just creating another trust, except for it's not like out in writing, or you're not really paying off a debt. You're just creating more debt.
Exactly. Yeah, that's exactly what it's saying. Yeah.
I'm sorry, you can go ahead. I'm sorry.
Okay. Okay. We are forming Federal Reserve notes, and that is just your purchase. You aren't purchasing anything. You are forming a trust. The same way at the gas station when you buy gasoline for your car. You aren't buying gas. You are forming a trust. Everything today has to be a trust. We are forming hundreds of trusts a day, probably in some cases. Are we treating them as trust? Did we realize they were trust? I don't think so. Now, if they give me an offer that comes in the mail, in an electric bill, I'm going to treat it as a trust. It's an offer for a debtor-creditor relationship. Only you don't know that it is a trust. I am going to express it as being a trust by forming the 4 elements necessary. I'm going to have intent, purpose, parties, and specific res. I'm going to turn that offer into the specific res. I'm going to return it to them as the special deposit under trust. If you look under Black's 4th edition revised, it says under the definition of trust deposit. A trust deposit is for the purpose of the depositor to make a payment for an obligation or a debt or some other purpose. Whatever the grantor wants to do, he really can do, as long as it's for a lawful means. I could use that deposit to pay a debt or an obligation. I could give the specific order to do conversion and convert the assets to, say, money, whatever their money is, and take care of the debt. The remedy is really not in debtor-creditor, it is under trust. We are really moving titles in trust, functioning as commerce. My bond is my word, and my word is really my bond. And really, we are talking about a trust. A pledge, a duty, an obligation for a party called the trustee to do whatever they will for the purpose of the grantor for the benefit of another party. The third party could be another party, or it could even be the beneficiary or the grantor himself. So what I liken to debtor-creditor under AFV/RFV is really in Gilbert's law summaries. Trust on page 127 under A, there, and section 441, it is talking about the alienability of beneficiaries' interest. We also want to see section 98 on page 27 for a tie-in. Number 1, right to transfer in general. Section 441. Beneficial interests in a trust are freely alienable. That is a lien by the beneficiaries, unless there is a valid provision to the contrary in the trust instruments. Thus, A beneficiary can assign, pledge, or encumber her interest, or even transfer it in trust for another. Also, if the interest is not conditioned on the beneficiary's survival, it will pass by will or by intestate succession. And then rational. The beneficiaries are equitable owners of the trust estate. Their interests in bracket title are property, and each therefore has power to transfer and convey her interest in the trust to the same extent that she could transfer her other property. B, transferee's rights, section 442. Here is what is likened to AFV/RFV, but it's not actually that. A beneficiary can assign only such interest in the trust as he or she has. The transfer is not a transfer of the trust res itself, but only of an equitable interest. Beneficial title. Therein, whatever conditions or limitations a lien attached to the beneficiary's interest prior to the assignment apply against the assignee, that becomes the hot potato. Whoever you give it to or assign it to now has the hot potato. That will be the person you will return it to. Once it's attached to the beneficiary's interest, I flip the hot potato to the new assignee, and that hot potato transfers with it. There is your AFV. That is how we would treat something similar under trust, but it is likened to a debtor creditor. It comes into being able to make the claim that there is a trust. What if the judge says, I don't see a trust here? You have to prove a trust. That was the marked truck door opening for you to drive that truck through when the judge says that. That is an opportunity to prove the case that there is a trust. How am I going to prove that there is a trust? Intent and purpose is by the grantor. That is pretty simple. The parties also is also simple. There are only 3 parties to the trust: grantor, trustee, and beneficiary. Since I am the grantor making this out, signing everything, granting everything by my signature, all I have to do is define who the beneficiary is and who the trustee is. Then the specific res will be the actual offer itself or the case itself. What I would want, turn the offer into the trust res by using the moving titles, by using the moving titles platform. If there was not a title, I would have to create a title first, claim that title, then merge that, and 3, move that title if necessary, if I wanted to terminate the case. Or I could, 4, come in and compel the trustee to do his duty for the disbursement if he didn't do it, after I expressed and proved the trust in the first step. I've got the specific trust res as property. I am putting it into special deposit once I put it into special deposit for the purpose of whatever I wanted to use it for the beneficiary. If I am the beneficiary and the grantor, then the trustee has to do the duty to say, pay the obligation, which is nothing more than the same scenario on a mortgage. Everything is really operating the same way. Once we get the model down, we can put the model up and apply to anything at all. Any kind of offer that comes into the mail, whether it be an indictment, a charge for a bill, or whatever you want to call it. Proving that trust, I am going to have to be able to create records that are evidence that are not objected to in court. I have to know a little bit about evidence rules. And one of the things we use is a notary, because a notary's record is self-authenticating and is outside the hearsay objection to hearsay rule. That is why can you move it up, please? That is why we use a notary on everything. A notary is going to certify it, and that notary record actually becomes the evidence. I need to prove the trust because a trust forms upon the present transfer of the trust property, which is the offer. Whatever the trust property is, the specific trust Rez. When I form a record of a transfer, which is one of the methods of formation of a trust, when I have two records to substantiate the transfer, then I have created a trust. There are 4 methods of creation of a trust. Declaration by words or conduct. 2, transfer, which is under UCC 3-200, see Appendix A, which is negotiation. A, endorsement, which is a signature. Anytime somebody signs, that is an endorsement. B, delivery. C, assignment. That is what we are going to do on a UCC-3 after we claim it on a UCC-1. And D, by operation of law. And then 3, appointment. Contract, which is going to be formed in the future in the trust. The one we are going to use the most is number 2, transfer, which is going to be an endorsement and a delivery. I'm going to prove endorsement on a green card sent by certified or registered mail. When they get the green card, they are going to sign it. The signature is like an endorsement. It's going to prove also delivery, which is one of the methods under transfer. Here we have a method of transfer representing transfer or method of formation of trust being endorsement. We have delivery and assignment on a UCC-3. When I do a UCC-3 after claiming it on a UCC-1, it is mine. I can do something with it. Assign it to somebody. I'm going to assign it, say, to the trustee, whoever that may be. The trustee is going to be a present transfer, proved by the endorsement and delivery, with the green card of a specific title representing the trust Rez. At that moment, the trust is formed. I'm going to have a notary certify that it was done on a presentment. Oops. Endorsed and delivered on the green card. I'm going to have an assignment on a UCC-3 and certified copies of that pulled out. I'm also going to put a notice in the county of a filing of UCC-1 and pull that out certified. Now, I have got multiple records to prove that I transferred trust property. That is the main thing, to prove by record that you transferred specific property to the trustee. That is when the trust forms. Now we've got a trust. I can prove I've got a trust. Wow. Wow, wow, wow. I think we should all concentrate on doing the trust.
Right. So we can stop here for today and we'll pick up on page 7 Tuesday.
Yeah.
Okay.
It's funny how everything now is coming together,
Ain't it
without
right?
having to beat about the bush with all the other stuff we're trying to put together.
Yes, I agree. I'm like, the universe, I don't know what's going on, but it's just answering all the prayers, I guess. But I definitely, like I said, I've been putting the petitions in for a while, y'all. So it's just manifest time, period.
It's manifest time, yeah.
And I know y'all have too. So, we've been on the same accord. And when there's 2 or 3 gathered in, in the midst, there it is. It's going to happen. So we've been
because you know what? When we get all this, we get everything together properly, we can buy a property using moving the trust, and we can form a community.
Yes.
Makes life so simple. We don't need to, oh my God, just get that done.
And you know what else I was thinking while you were reading, Mother? It's like, this is the answer. There really doesn't have to be any division at this point between black and white. And we ain't got to try to put people off our land because there are still some good people here. All we got to do is go after what's ours and what's due to us.
Exactly.
You know what I'm saying? We can all live here in harmony and just get along. No hatred.
And just get along.
But we're the ones always been living in harmony. It's them that's not living in harmony. It's
somewhat. I agree to a certain extent, but it's when you say it's when I say it's them, it's just a certain certain group, and that's those
the elite. The elite is what we're talking about.
Elite. Right.
Because they are the one causing the problem on the planet.
Yeah, they are.
Because these other people today are also affected, and they don't even know that. Some of them don't know until they're brought to just like we found out about what's really going on.
Exactly.
Yeah.
But the thing, when you were reading about the birth certificates, the one on the left and the one on the right, the one on the left, they basically telling us that we're foreigners in our own land. I'm like, we were already here.
True that. I agree. I do agree with that.
So we got to wake them up.
But I'm not. This our birthright. You know what I'm saying? We were already here, so we're not foreigners in our land. They are. We're not.
They're the one they are foreigners. Yeah, exactly.
Right.
Wow.
Now.
Okay, well, ladies, I appreciate you. We it's coming. It's all coming together. I feel by the end of this year, by the end of this month, we're gonna have everything down packed and ready to go on the 22.
I'm ready to go. Yeah, in January.
Okay, so let's just keep studying and reading and see.
Thank you so much for this platform. It's been really beneficial to me and I'm sure to the rest of the mothers.
Yes. Very enlightening.
Yeah.
Oh my goodness. It's so exciting.
It's so crazy that we're the only our little clique here. It's so cozy.
Yeah, I said that because we got
so huge.
They don't know no better. That's all right though. They don't know no better. We got 100 people in the group chat and it's all, but that's okay. That's how the numbers work sometimes. That's with everything. So you just got to keep building and they'll come. Like we said, as we get more results, they'll come.
They will come. Right. Because I know there are hundreds of people wanting to get this remedy done.
Right.
And if they know somebody that can help them, trust me, they're going to rush down.
Right.
Yeah.
I know, too bad we're not all in the same place. We can have our own little company and just take care of everything,
Right. Exactly. That's it. Yeah.
Yeah.
Because you can charge for your services.
Yes. This is a lot of information. It's a lot of prepping, you know.
Yeah.
And
and
a lot of people, they don't want to be bogged down with they just want what they want done. And then if you just say this is how much it's going to cost you, we do everything for you, they're ready to go.
Right.
Yeah.
As long as it's reasonably priced, they will do it.
Yeah. And then once they see the success rate, oh yeah, they probably be like, okay, where how much do I pay?
Right. Right.
So, you know, it's coming together slowly but surely. But I know for me, mother, I just need me a good checklist so I can go down my little checklist. And once I get one thing done, I just check that block and move on to the next and move on to the next.
Okay.
That's it. Yeah. That's it.
Well, right now I put the 1099 stuff that's on the top of my checklist. So I'm just waiting for that to come back. But in the meantime, I'm still be working on my DBA, getting the power of attorney. So that's kind of like, you know, first step things. But those 1099As.
Yes, I'm going to start working on that now. The DBA.
Mm-hmm.
Yep. Yeah, I need to order those forms. And then I know Mother Flora had said something about copywriting our name or something.
Yeah, I sent that to you in the letter form. It's a copy of the copyright letter that you're going to send off.
Okay.
And that's another thing we can do right now too, is do the copyright.
Did you send me that also?
Did I, Mother? Let me see. I don't know, but I'll send it.
I need to do one for myself. I don't know where I don't know whether the one I did the first time was even good or not, but I got it from the group that I was part of at the time.
Oh, okay.
Yeah, I think I did send it to you.
Okay.
Yeah, the it's 3 documents in one. The POA, the rescission letter of rescission, and the TM. It says TM copyright.
Okay.
Okay.
I had one more question, Mother Shay. As far as the class for that gentleman on the 19th, do we have to subscribe to his channel or anything?
I would say I put
his information in the Telegram.
His information in the Telegram is just like a paragraph of him of introduction. So you're just gonna have to click on like his name to get to the actual chat. And then I think he's saying,
is that for Christopher Hauser?
Yes, for Christopher Hauser.
Okay.
Yes. He's gonna. I think he said he's gonna either put it in there or email everyone. So just be in the chat. I think that's where he's gonna put it at. Yeah.
Okay. Thank you so much.
I'll let everyone know most definitely.
All right. Today has been exciting. Oh, it's been great.
Yeah, it's very exciting today.
It is. Well, we appreciate y'all. Love your energy. Love it. You know, I know everyone is excited. So
yes, I love you all as well. Thank y'all for sticking with me through this and just encouraging me to keep going, because this is definitely encouraging me to just find the answers that we're looking for. So
yeah.
That being said, I love you all. You all enjoy the rest of your day, and I'll see you all on Tuesday.
All right. You all have a safe day.
You too. Have a good day. Bye-bye.
Peace, peace, peace.
Love you. Peace and love.